Every year, millions of people apply for a non-immigrant visa to travel to the United States. And every year, millions of people are denied. Now, the most common reason given for a visa denial is 214B. Hi, I'm Travis. I'm a former visa officer and licensed U.S. immigration attorney. I spent almost 7 years as a career diplomat with the U.S. State Department. And during that time, I interviewed over 80,000 visa applicants from all over the world. Today, I want to talk about 214B. What is it? Where does it come from? And what does it mean for you? I'll give you a couple of tips on how to explain your unique circumstance during your next visa interview so you hopefully don't fall victim to the requirements of 214B and face a rejection. So let's start with a couple of numbers. In 2022, the State Department reviewed roughly 8 million visa applications. Now, of those 8 million applications, the majority were issued, but still roughly 1.3 million were refused, representing almost 19% of all visa applications. Now, if we look at B1, B2 visa applications, which represented roughly 50% of all applications in 2022, more than 1 in 4 applicants was denied. And again, the most common reason given for a denial is 214B. It's a similar story with student visas. The F1 visa is the most common visa category that most students will apply for. And we saw over 500,000 F1 applications in 2022. Now, of those applicants, and again, this is across all countries, 35% of those applications were denied. Now, this number can vary widely across different countries. Some countries have a very low refusal rate. In 2022, Israeli passport holders saw a 2% refusal rate across all visa types, while passport holders from Mauritania saw roughly a 90% refusal rate. But at any rate, the most common reason given to a visa applicant for a denial is 214B. So let's talk a little bit about 214B. What in the world is this mysterious figure? Where does it come from? What does it mean? And more importantly, what does it mean to you? Well, 214B comes from a federal law, the Immigration and Naturalization Act. And it actually stands for a subsection of that law. Not surprisingly, Section 214B. And that law says, in many, many words, every alien other than a non-immigrant described in subparagraph L or V of Section 101, subsection A, subsection 15. Don't worry, I'm not going to read this whole thing. There's a lot here. But in plain English, what this actually means is that every visa applicant is essentially presumed guilty until they can establish otherwise. Now, this is very strange for America. The United States has a presumption of innocence until proven guilty. That means that even if you are charged with a crime and you go to court, there's a presumption that you are innocent until the prosecution can prove that you're guilty. Well, this law for non-immigrant visa applications is actually the opposite. Every non-immigrant visa applicant is presumed to be what we call an intending immigrant. That essentially means that you're not a non-immigrant. You're not going to come to the United States for a short period of time and then go back home. On the contrary, you're actually planning to move to the United States. Now, that presumption is not guaranteed. There's a way to overcome that presumption that you're not going to stay for a short period of time. And that's what visa officers call overcoming 214B. So how do you overcome this presumption that you're not going to comply with your non-immigrant visa, with the visa that you're applying for? Well, there's a couple of ways to overcome 214B. To do that, first of all, applicants must prove that they're going to qualify with the visa that they're applying for. Now, for students, this is fairly straightforward. Generally speaking, without going into all of the legal requirements, student visa applicants simply have to prove that they are indeed planning to go to the United States to study. Maybe they are planning to complete a degree program or attend a few classes for a specific duration of time. Now, for a tourist, on the other hand, this gets a little more nuanced, because you actually have to establish that you are indeed planning to travel to the United States for a vacation. Maybe you can show plane tickets Maybe you can establish that you've already purchased park tickets for Disneyland, which, by the way, is not always advisable. It's best to get your visa before you make super firm plans. But at least you should be able to talk about what you intend to do in the United States. How do you plan to travel here? What sites do you intend to see? Where do you intend to go? How long do you plan to stay here? These are really interesting and important facts for a visa officer to understand that you are indeed a tourist and not somebody that's simply planning to move here permanently. Now, beyond simply qualifying for the individual visa category that you're applying for, every applicant must also establish that they have ties to their home country. And the law actually says that you need to maintain a residence abroad that you have no intention of abandoning. Now, you could just establish that you own property. Maybe you own a house, a piece of land, an apartment. And because you own this property, it's very unlikely that you're going to simply abandon the property to move to the United States permanently. But to be very clear, there is no requirement that you own property to qualify for a visa. People every day get visa applications granted who live with friends, live with parents, rent. That is totally fine. So how else can you establish that you maintain a residence abroad that you don't intend to abandon? Well, there's a couple of ways. First, you might show that you have a job. And because you have a job, you're not simply going to walk away from your obligations, from your responsibilities, and move to the United States permanently. Now, it's very important to be able to discuss your job. What are your responsibilities at work? What is your job title? How many people maybe report to you? What kind of hours do you work? What is your salary? These are all questions that a visa officer might ask you, and you need to be prepared with precise, confident answers to establish that you really do have a job that's going to pull you back after a short stay in the United States. Now, another opportunity for visa applicants would be to show that they have family ties. Now, maybe you have small children at home. Maybe you're caring for your parents. Maybe you have a spouse. This is another way that you can show that it's very unlikely that you'll simply pick up and move to the United States permanently because you have to return home to meet these obligations. Now, again, you should be prepared to explain your familial ties in detail. How many children do you have? How old are they? Where do they go to school? What are your general day-to-day duties, maybe with your elderly parents? How long have you been married? All of these are crucial ingredients to a visa officer's determination that you will likely return to your home after a short stay in the United States. Now, for students, you might also show that you have to return home to complete your degree plan or to complete your school program. Now, again, it's very crucial here that you can explain your school situation clearly and succinctly to the visa officer. Where do you go to school? What degree are you pursuing? Maybe show some report cards to show some grades that you've made. Be prepared to talk about classes you're attending, hours that you're generally in school, what you enjoy studying, what you don't enjoy studying. All of these are really, really good ways for you to prove to the officer that you are indeed a student. And because you're a student, you're not likely to abandon all of that hard work and investment that you've put into your schoolwork just so you can move to the United States. And finally, you might also show that you're likely to return home after a short stay in the United States because of social commitments and social ties. Maybe you are planning to hold a large party for your elderly parents or for your spouse to celebrate an anniversary. Maybe you have commitments with different social clubs. Maybe you are a coach for a child's football team or basketball team. These types of commitments may seem a little bit trivial to some, but these are actual real responsibilities that many of us do hold very dearly. And we're not likely to simply abandon all of these responsibilities so that we can violate the terms of a non-immigrant visa and move to the United States. But again, just like all of these other bullet points here, you should be prepared to speak about these responsibilities, these obligations in detail. You need to convince the visa officer that first, you're telling the truth, which you should be, but also that these are important to you and that these are going to be enough of an incentive for you to go back home after your short stay in the United States. But there's also some unwritten applications of 214B. Now, because of this presumption of guilt, this presumption that you're going to immigrate to the United States and live in the United States permanently, visa officers will apply 214B generally to refuse visa applications where there's doubt, where there's confusion, or maybe something just doesn't seem quite right. I've had colleagues say, when in doubt, apply 214B. And it actually does make sense the way the law is written. Because again, if an applicant can't overcome this presumption, they don't technically or legally qualify for a visa. If you faced a denial at your visa interview in the past, you may have gotten a very short explanation from the visa officer that you didn't overcome 214B, or maybe that your visa application was denied under 214B. You may have even gotten a short form letter from the consulate or embassy where you applied stating the same thing. You didn't meet the requirements under 214B and therefore your application was denied. But what it really means is that you did not convince the visa officer either A, that you would qualify with the requirements of the specific visa that you applied for, or B, that you would return home after a short visit to the United States. And that's why it's so important to tell the truth, to be honest about your circumstance. You may have some situations that you don't think will look very good in your interview. But instead of hiding those, it's best to be upfront about them, to be honest, to be upfront, to be confident, and to explain your circumstance in detail so that the officer doesn't think that you're hiding something or presenting a story that you think they want to hear. And now this is where ZF Visa and Immigration can help. Schedule a 30-minute consultation with us. We'll take some time to get to know you, to understand your circumstance. We'll learn about why you plan to travel to the United States, whether it's to study or for a vacation or maybe for business meetings or something altogether different. And then we'll work together to come up with a strategic plan to present your circumstance in a very confident yet succinct and detailed manner to the visa officer. And while we can't guarantee success, because of course we are not the decision makers, what we can guarantee is that you will now put your best foot forward. You will have all of the needed details and all of the needed strategies to explain your circumstance to the officer and hopefully get a positive outcome. So reach out to us today. Schedule that initial consultation. You can find us online at zfvisa.com or send us an email to info@zfvisa.com and we'll reply with a couple of links where you can find some available time and schedule that consultation. We look forward to hearing from you and we wish you all the best in your visa application. Thanks.